Hi, everyone. I'm Bob Ward, and welcome to the Boston 25 Brian Walshe Trial Podcast. My name is Bob Ward. I cover mostly crime and the courts, and I've been covering Brian Walshe almost from the very beginning. I was out there in Cohasset when the state police were looking for Anna Walsh, and I've been covering it ever since. Joining me right now is trial attorney Elyse Hershon. Elyse is a criminal defense lawyer who has a passion in defending murder cases. In 11 years, Elyse has been co-counsel in 17 murder cases, and we're going to talk about one of those cases today. In this podcast over time, and Elyse and I will be taking a look at all sides in this case, not just from the defense side, so we can have a better understanding of what is actually going on. Elyse, thanks for joining us. I'm excited about trying this out and doing this.
Thanks for having me. I'm excited too. I will do my best to be as non-defense leaning as possible.
Absolutely. Well, opening statements, first witnesses set for Monday, December 1st. But before we get to that, you are a defense attorney. If Brian Walshe is your client, what are you telling him? How are you advising him right now?
So I think the first thing, to make clear is I'm not part of the defense team. I don't have any direct connection to Brian Walshe. Just bringing my experience with my own, working on my own murder cases and other types of criminal trials to speak with you and see if we can analyze and predict what's going on. So we don't know what the defense strategy is at this point. But in terms of, there was a very surprise and shocking turn last week when Brian Walshe pled to two of the charges, and now we're just left with the first-degree murder charge. I think most times in these types of cases, the client does not take the stand. There's no burden for them to take the stand. The burden is entirely on the Commonwealth. But I think this case is a little bit different because I think people are, like in any criminal trial, they want to hear from the client. There's a lot of reasons that a client doesn't take the stand, and many of them have nothing to do with whether they were involved or not. I think it's clear from the plea deals or the plea offers that he accepted last week that he was involved in disposing of her body. That was something that he also, within that, acknowledged that she's dead. For most of this time that we've been waiting for this trial, he hadn't done that. So the fact that he misled the police, he's acknowledging he told them that she was missing when in fact he knew she was dead and he disposed of her body, but we still don't know what happened to cause her death.
Yeah, I mean, that was the big shock last week. You and I talked about this, and it kind of came from nowhere because since 2023, it has been not guilty all the way. You don't know the whole story, to, well, yeah, he did lie to police, and oh, yeah, he did dispose of the body, and oh, yeah, I am no longer married to Anna Walsh. It was a real shock to the system to see that, but it's part of the strategy. And there's no plea deal in this case. The Commonwealth has not agreed to anything. His change of plea has been accepted, but the Commonwealth, from filings, we learned that the Commonwealth said, you know what, you're not saying anything on the murder side of it. We're not going to agree to anything. But the judge accepted, the two counts. So what happens now when this trial gets started? Does the jury hear about those plea changes? Do they hear about those notorious internet searches and what he said to police when they came knocking on his door?
That's a great question. I think that's a question I'm getting a lot as well. I expect that even though Walsh pled guilty to those two charges, the facts and evidence supporting those two pleas or those two counts are still going to be a focus for the prosecution in this trial, meaning they don't have, as far as we know, the prosecution doesn't have an eyewitness on their witness list as to how she died. They don't have it on video at the time of her death. So we're really missing, or the prosecution is really missing, what happened in that time. So what they're going to try to do, I expect, is to piece together what happened before and after and ask the jury to connect those two events. So in terms of disposing of the body, I expect that the prosecution is going to introduce a lot of evidence of that, both from the Google searches all the way to what they say that they found, the evidence they found in the dumpster near his mother's house in Swampscott. So that would be related to potentially how she died or the disposal of her body. We just don't know. And I don't think the prosecution knows, and that's going to be a challenge for them.
Back when all this happened and we first learned about those internet searches, the comment I heard most often out in public was, why bother having a trial? He's as guilty as the day is long. Let's just get this over with. But what about now? You represented a few years ago, you had a very interesting case in Worcester involving a dismemberment. The facts aren't, totally the same, but they're very similar. Can you walk us through what happened with that case?
Yes, I was co-counsel. I second sat another attorney on that case. It was a murder trial out in Worcester. It was a dismemberment case. Um, I never thought I'd see another case involving dismemberment, maybe in my career, but here we are again. With that case, is a little bit different. It was two brothers, and they both got in an altercation involving what we call mutual combat. So they both, without knowing who started what, they both stabbed each other multiple times with what was a butter knife. And so there were multiple stab wounds, but they were very, very shallow. So it was unclear if there was one big blow that caused the death of one of the brothers. It's unclear. But there were multiple stab wounds, certainly over 40 or 50 on the brother that ended up dying. And the brother that we represented did not call the police at that time, went into some sort of fugue or psychological state, and ended up dismembering his brother using a saw, not an electric saw, but using a handheld saw over a couple of days, and essentially amputated the arms, legs, and head, and then proceeded to take those body parts and put them in plastic bags and put them in the storage shed behind his brother's house. Now, the reason I can speak to this and talk about this is, number one, it's already gone to trial. And number two, in a very unusual turn of events, my client took the stand and he actually acknowledged his part in the disposal of the body, right? So a similarity here. My client took the stand, having no burden to do so, and explained that it was a self-defense case. His brother came at him and he was defending himself. And that what happened after the fact, the dismemberment of the body, was not in his mind at the time of the death, at the time that they were in a fight and he killed his brother. So I think what's interesting here, and but there was a body in that case. So they could say the death was caused by multiple stab wounds, right? They couldn't determine which one. They had an anthropologist testify. The difference is that in the Brian Walshe case, we don't have a body, we don't have body parts, as gruesome as that sounds. So I think that's a huge difference that they're not able to determine. The prosecution's not able to prove cause of death here. However, the similarity is that both in the case that we went to trial on and the Brian Walshe case, it appears that there were efforts to go purchase items to dispose of the body, right, potentially after the death, which means, and which we argued, at the time that in my case he killed his brother, he didn't have those items, the ties, the storage bags, the different pieces that he went to Home Depot and purchased after the brother died. And that is similar here, which actually shows that it was not in the mind of the defendant at the time of the death. So I think that actually could be helpful to the defense.
And the internet searches also suggest that as well. It's all, from what I understand, there were searches for divorce and inheritance and those sorts of things, but there were other searches pertaining to the body, was about what to do with the body as it's decomposing and how to get rid of a body and that sort of thing.
Exactly.
I don't recall any kind of an internet search saying how to kill someone. So that is an important difference. I just have to go back. In your case, and the reason we're bringing this up is that in your case, the jury had all those facts, and they're gruesome facts. But he was convicted of second-degree murder, not first. And the difference is first-degree murder is mandatory life, no parole, which is what Brian Walshe is looking at. Your client was found guilty of second degree and is eligible for parole. One day, presumably, will get out. So I just get stuck on, present these facts, you present this client on the stand, and you have these facts about this gruesome thing, sawing off your brother's head. not with an electric saw, but with just a regular saw, and the force that must have taken and how grotesque that is. But the jury was able to look beyond that. And they had, I presume they had photographs of the evidence of what was found. That is a steep hill, but that jury was able to put that aside and come to that second degree. And I think that just tells you that something like that is possible with Brian Walshe. This is not necessarily a slam dunk case. What do you think?
Absolutely, it's not a slam dunk case. What's missing here are the very impactful photos, right? That was in the trial that I did on the dismemberment case. There were photos that were extremely difficult to look at, and that's something that you do. We did have to vet with each juror when we did the voir dire to pick a jury. You know, are you going to be swayed by these pretty horrific photos of body parts? Are you going to be able to focus on what actually was in the mind of the defendant when he killed him? And that relates to exactly the judge's instructions, which they give at the end before the jury goes to deliberate. Sometimes you don't know if people are going to say, we don't think he murdered him intentionally and deliberately, but we just can't look past those photos. That's not following the law, and that's not following the judge's instructions. So this jury is going to have to separate how they feel about what happened personally, and they're going to really need to focus on what is the evidence that Brian Walshe killed her, and if he did, was it a deliberate and intentional killing?
All right, so let's go to that. So well, first off, during jury selection, the defense attorney was asking jurors if they had heard anything about the case. What did you hear? And potential jurors who said, well, a guy murdered his wife and now he's on trial. That person is long gone.
Right.
But at one point, a defense attorney said, can you keep an open mind to whether a murder even happened? And it suggests that that's where they're going to be going, that the death of Anna Walshe was something else. It was not a murder. Maybe self-defense, like in your case, maybe something else, an accident or something. I don't know. But if that is the case, if there's going to be an alternate theory, and as you mentioned, there are no witnesses here, no eyewitnesses that we can see on the witness list that's been presented to us, doesn't that mean that Brian Walshe has to take the stand? What do you expect to see him on the stand?
It does not mean he has to take the stand. He has a right, a Fifth Amendment right against self-incrimination. He also has a right to participate in his trial and not have the burden to prove anything. So expecting him or wanting him to testify is actually one of the voir dire questions, one of the pre-qualifying questions that are asked of jurors. Do you expect the defendant to testify? Because that's not what the law says, and that's not what the Constitution says. Of course, in any case, do you want to hear from a defendant? Of course. But there are a lot of factors going into that. Now, if he took the stand, his lawyers cannot put anyone on the stand that they know is going to lie, so he will have to take the stand and tell the truth. It's certainly for consideration whether he's mentally stable or secure enough to take the stand and suffer cross-examination. That's difficult for anybody and can certainly twist something into something it's not. So there's a lot of considerations, and the decision for him to take the stand is up to him, but that doesn't need to be decided till after the Commonwealth finishes presenting their side of the case. After they present their evidence and witnesses, they rest, then the judge will turn to the defense. The defense can put on, and probably will put on, their own witnesses, perhaps some forensic witnesses, perhaps a private investigator, and then they decide whether the client is going to take the stand. And usually, if that happens, it's the last witness in the trial. And that's not something that has to be pre-decided. I guess
I'm always stuck on, well, how are you going to get an alternate theory in on Anna's murder if you don't call Brian Walshe? But I suppose through questioning of, we know they found a bloody knife and blood on the floor in the basement. That we know they found a saw with who knows what's on it, probably her DNA on that. But I guess through questioning, right? A defense attorney can say, well, yeah, that's a knife and there's blood on it, but you don't know how that knife was used, and just raise reasonable doubt on the government's case. Is
Absolutely.
that how it should be done?
I expect that the defense is going to be really reiterating that throughout the trial, that what happened after is not indicative beyond a reasonable doubt as to what actually happened to cause her death. Are those tools to dispose of a body that were used to dispose of her body, as grotesque as that is, or are those murder weapons? The Commonwealth needs to prove that they're not just dismemberment or disposal tools, that those are murder weapons or weapon. And right now we don't have a body that a medical examiner is going to testify this is how she died. They cannot even say without a body to evaluate whether this is an accident or homicide. So the manner of death is homicide or accident typically. And that's something that's on the death certificate, and that's usually what starts out a certain case being labeled a homicide or not. If Anna Walshe fell and hit her head and he freaked out and disposed of her body in a really grotesque way, that's not murder. That's not first degree murder. That's not second degree murder. That's not even manslaughter. That's pure accident. If there was a verbal altercation with them that turned physical and she somehow died, then that's a self-defense case, or excessive, what we call is excessive self-defense. So basically self-defense using excessive force. That's not murder either. That's not first degree. That's not second degree. That would be voluntary manslaughter potentially. So he could have had nothing to do with how she died, or it could have been self-defense, or it could have been some type of manslaughter. So there's a lot of options still open, which is the definition of reasonable doubt. If you think he caused her death or he killed her but don't know how, that's an acquittal by law and by the jury instructions. So that's going to be really interesting. The Commonwealth is going, I expect, to put in the evidence of the disposal of her body in the Google searches and ask the jury to make that link to his intent at the time that he killed her. But speculation is not enough for beyond a reasonable doubt. The defense, I expect, is going to point out all the other possibilities that could have caused her death, which is the definition of reasonable doubt. So if a juror doesn't know how she died, that's not a conviction. They cannot convict on that.
And that's why it's so difficult to bring a murder case when you do not have a body. It's not impossible, but it's not an easy thing to do. Now, another issue here in this case, and kind of hovering over not just this case, but other cases in Norfolk County, is Michael Proctor. Now, he is the disgraced former Massachusetts State Police Trooper who's no longer a state police trooper because in the Karen Reed case, we saw what happened with his personal phone and the inappropriate comments that were on there. When this happened, when Anna disappeared, Michael Proctor was investigating this case as well, and was one of the main people investigating this case. Michael Proctor is a defense witness, so we expect that he is going to be called. How big a problem could Michael Proctor be for the Commonwealth?
So that's really interesting. He is on the defense witness list. It doesn't mean that they're definitely going to call him, but it's certainly a move to put the prosecution on notice, perhaps strategically to make them a little bit nervous that they're going to have to answer some questions. From a fall from grace investigator, he was fired as a result of his actions in Karen Reed. He acted inappropriately, improperly, unethically, and there were a lot of text messages on his phone that were on his personal phone. That's not something that typically gets turned over in any case, never a murder case or any type of criminal case. An officer's personal phone is usually not subject to discovery. The fact that the FBI got involved and those phone records were subpoenaed, that's a big deal. That's highly unusual. I've actually never seen that in my career. Never mind getting access to a police officer or investigator's work phone. So there's likely a lot of content on that phone that don't just relate to his investigation of Karen Reed. He was involved in this case. So in Karen Reed, the defense was claiming that he planted evidence or falsified evidence, that he removed some of the glass from the car at the scene, the plastic from the taillight, and planted it, right? So there was a lot of cover up and fixing allegations and undercurrent in that trial. That could come up in this trial. What was exactly his involvement, and was it tainted or is it tainted? Somebody acts unethically in one case and they're investigating another case with at least some overlap. Doesn't that call into question how he handled this case? So the prosecution is going to have to be prepared to answer that. And we're going to have to see if they have somebody else that actually handled more personally the Brian Walshe case or how involved he was. So it should be really interesting. It's certainly fodder for cross. It's certainly fair game for defense to call a witness that was working for the Commonwealth, but could have really messed it up.
Yeah, and we don't know what was on his phone, if anything, concerning Anna Walsh. That information is not out there. So, we have to keep that in mind. But it is something that is out there. I want to go back to the change of plea. So we know that he's changed his plea to guilty on counts 2 and 3, but not the murder. Is it possible? So on one side with the Commonwealth, I mean, this is a big case. A lot of people are paying attention to Brian Walsh. I feel they cannot afford to lose this case. It's a first degree. They want that first degree conviction. But there could be issues, as we just talked about. For Brian Walsh, he needs to win his case, because if he doesn't, it's life, no parole. And he would probably be shooting for second or something less than that. So given that both sides could be motivated to have some kind of a plea agreement concerning the death of Anna Walsh, I know we're up against it. We're in the 11th hour before opening statements are set to commence. Is it likely that there could be a change of plea for the death of Anna Walsh?
It's a great question. Technically, a defendant can answer a plea at any time, anytime, even after the trial starts. So we don't know what those discussions are like, or if there are any, between the defense team and the prosecution. I would expect it to be unlikely. Typically, if there are multiple charges and there's going to be some sort of plea deal, they do what's called a global deal or global negotiation. Essentially, let's resolve everything together, and the Commonwealth comes off of life without parole, and the defense comes off of, free or not, or nothing. So I think certainly he's able procedurally and legally to enter a plea at any time. I find it unlikely, given that he already pled guilty to 2 of the charges. Usually that would have been, okay, let's agree on, for example, a manslaughter, and we'll take these 2 other charges, guilty plea, but we'll run them concurrent, which means at the same time as the homicide, or on and after, which means in addition to. So I think if they were close on the homicide, or they were going to do that, the time was it last week when he entered the plea for those 2.
Well, it's a fascinating case, Elyse. We could talk about this for another hour, but this is the time that we have. And but you're not going anywhere. You're going to celebrate the holiday, and we're going to sit down and talk about the trial as it progresses over the next few weeks. They expect this trial is going to take 3 to 4 weeks, which puts it right up against Christmas. And boy, I feel bad for these jurors that, they're already chosen. They can't talk about this case now as they sit down for Thanksgiving dinner. And if this case goes long, they're going to be under that same prohibition, not only about talking about it, but staying away from social media through Thanksgiving and Christmas and who knows. But anyway, thank you for joining us in our podcast. We'd love it if you come back to us next week. I think we're shooting for Thursday or Friday. The end of the week is kind of a review of what happened during the trial. If you have a question about this case, send it to me. I'm on Facebook. My page is Bob Ward Boston 25. You can also reach me on X, where I am B Ward 3. If you got a good question, if there's something that you think we're not even considering, just let us know, and maybe we'll use it. But again, thanks for joining us, and we'll see you again next week. Thanks, Elyse.
Thank you, Bob. I look forward to talking with you next week.